This channel does not promote any violent, harmful, or illegal activities. All content provided by this channel is meant for an educational purpose only.
Page 436.
437. 436 means the gentleman was called.
Hmm.
And on the same day at 4:20, the learned judge records that the learned advocate for the petitioner has concluded his submissions.
Yes.
Now kindly take me, Lord.
Now the court puts the questions.
Put the question. On the same day, kindly take the last paragraph of that order at page 440, that is fourth page of that order.
Yes.
Last paragraph.
Supplementary evidence disclosing the documents as there. That you are doing.
Yes,
Supplementary evidence.
After conclusion, on the same day, first paragraph noted that the petitioners have concluded their submission. Last paragraph, supplementary affidavit of documents taken on record. Now, when was this? On 5th of April.
But what does it? What is the wrong, Mr. Bro?
There appears to be nothing wrong. Now, kindly take 19th April order.
Page.
Which is at page 444. Kindly see the first paragraph. After conclusion of hearing of the writ petitioners, if at all on 5th of April,
For completion of the pleadings,
I adjourn the matter and request the board to file their affidavit in opposition. After completion of hearing of the petitioners on 5th of April. Now I have been given the opportunity to file affidavit in opposition, when previously it was rejected.
This was accepted by you, Mr. Dutt.
Milord, it is not possible to run to the division bench with every order in appeal.
That line could have been recorded. Which what you are arguing today, your counsel was present.
Well, I was present. I was personally present. I was present.
Then you have to go back to the judge and ask that what to...
Yes, I want to cross-examine that judge. 1875, I will place before your lordship.
What 1875?
Where, Milord, the judge incorporates his personal knowledge of any matter, how could that person be called? He cannot put into the judgment anything unless he appears as a witness. This is 1875 judgment. It's not like, Milord, dispensing justice over here doesn't mean that call anybody, anytime, anywhere, adopt any procedure you like. Without arguments of the petitioners, the judge records that the petitioners have concluded their submission. Next breath, call X. Next breath, call Y. Next breath, okay, you submit that document. Then, okay, board, you have not filed your affidavit, file your affidavit. But the proceedings has to be conducted in a manner which inspires confidence in the parties. But the order can be against me. The order can be against me. Why not? No, all that, Milord, we as counsels or the litigants that they expect is that in a proper proceeding where the court will hear the parties and pass orders.
Yes. All right, now we will say you have concluded. You will again come and say that I have not concluded.
Therefore, I am saying I have not concluded.
We will face that comment again.
No. Milord, this is where, Milord.
When I say the Advocate General has concluded his argument, do I stop you from giving reply?
No.
I will hear you in reply.
Definitely. Milord, but there, yes, Milord, your lordships would hear me, provided on the next day I come and say that, Milord, I have recorded or I had submitted that the submissions are concluded, but I find I have left two judgments.
Yes.
Or I come and say that I have missed 2 points, or I have discovered something. So kindly permit me to reopen. Not that today your lordship will record that arguments completed, and the next day the court will allow my adversary to file their affidavit in opposition. Well, what is very surprising is, what I have shown so far, but in fact the petitioners ought to have been aggrieved that after you have concluded my submission, how are you allowing the board to submit their affidavit in opposition? I will not get a chance to deal with that.
Exactly.
Therefore, that is why I say it is surprising. Yeah.
Yes.
Then, my lord, finally, my lord, 11th of May, my lord, 2023, my lord, the hearing was concluded, judgment reserved, and on the very next day, well, there is no harm in delivering judgment on the very next day, but keeping the sequence in mind, where
12th. Judgment was on 12th. No?
12th, the very next day,
It was concluded on
11th.
Third.
My lord, Justice Sanjeev Banerjee, my lord, had imposed a rule on his lordship that his lordship would deliver a judgment within 48 hours. Hearing for 30 days, judgment within 48 hours. But I can understand, my lord,
What? His lordship did what?
his lordship used to follow that practice. That no matter how big the arguments are, I am going to deliver judgment within 48 hours. And the honorable judge scrupulously followed it. But but this is such a case. Why I say this? Right? There is something more than what meets the eyes. Why I take, my lord, this risk?
You need not traverse on that.
But I cannot, my lord. My lord, when, my lord, kindly permit me to say this, my lord.
We will hear him.
Yes.
Questions you have put, we will put questions to them.
Yes.
Then we will decide.
Your lordship would hear us first, or the other?
Yeah, that we will decide. আর প্রথমে লেখো মিস্টার দত্ত লার্নেড সিনিয়র
বাকি আছে, বাকি
কি আছে, আর কি বাকি আছে?
আর কিছু বাকি
ওটা আর্গু করুক, ওটা আর্গু
যা 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 আর কি বলছে আবার কিছু বলছে না
Milord, please record one thing, Milord, so that there is no misunderstanding. I have a few points left, but please permit me to raise those if I require, Milord, in reply. Otherwise,
Mr. Dotto, we are hearing you substantively. We do not shut out the councils. We never do that.
no, definitely.
If you have, and your friends will also not shut you off. That much of understanding we should
Right.
have. No, it is
Very good.
just a judge delivers a judgment after hearing it. We also put up matters for clarification because when it goes for our signature, doubts are, then we keep it. Ashok, now, after you finish, who is in aid of you? Now, then, Mr. Mojumdar, will I ask them to just a moment. We were wanting to know if you may be having additional points on what Mr. Dotto has submitted. So can we do this, that at least if we hear their part of the story,
hear us first. All the points, whatever points are there, get all the points. Can hear them.
but you people are how many councils we will hear?
Be as economical as possible. All council. But my lord, kindly hear us, kindly give us some timeline, we will conclude. We will conclude. But hear us all. I have one.
No, we would request you, both all senior councils are there. Why don't you sit and make a homework, and anybody, any one of you?
That's likely there cannot be anyone, but of course there would be very less number, not everyone. Not be one, be approximately 5, 6.
So you are representing which persons? No, which you are representing which person?
I am representing candidates who are appointed from 7.
No, ওই দেখো তো ওই অর্ডার শিটে এই ধরের নাম কিসে আছে?
Candidates who are in service.
সেজন্য তো তুমি আগে বলো তারপর আমরা এটা না
Hear us all. Why you not kindly hear us all?
No, Mr. Mujumdar, then the matter will never end. We are asking your assistance.
My lord,
I have I have compared myself in one matter, in one point. We have discussed this. We will not.
I'm led by Mr. Joydeep Kaur. He will argue on the point of section 165.
But that it's the point which may not require to enter into the entire domain of the matter that Lordship is seeing. There is a possibility. I don't want to disclose anything on that. There is a possibility that Lordship might find it is not such a big matter. It might come to an end on one point. There is a possibility. I test the couple of points from us. We have to
We have toiled ourselves, we have applied our minds kindly.
আমি কি বলবো যে আমরা ফার্স্ট ছিলাম আপিলে করতে?
You are representing the persons who have already been brought on record.
No.
Any one person say
we are the appellants.
you are appellants in the other appeals. In the other appeals, you people are the appellants. So how many people will argue before us? Some restriction has to be there. Everyone cannot take a one day every day.
As against 30,000 who are going to lose the job.
That cannot be. That is the magnitude of the dispute. So we cannot hear 36,000 advocates today. We will hear only restriction. No, Mr. Dhar, Mr. Mojumdar, you sit together and find at least. We will give you 1 day or 2 days. You finish it off.
But I led by Mr. Joydeep Kaur and Mr. Sujitan Mitra. But I need only a day.
We will allow these other appellants to argue. Mr. Dotto has taken, he has substantively argued. We would request you that the points which have been left out, you let us know.
But we will, Mr. Kaur will argue on the point of section 165.
For that, we will give you 2 days. We will fix the matter at 2 p.m. 2 days. We will finish off your argument and then we can.
Only one thing before that, my lord, because the appeal is not in proper form. Because of that, my lord, there are several addition of party which is implemented in pursuance of the court order. My lord,
we will sort it out.
Yes, and another thing is that, my lord, because the court asks 4 questions for taking instruction, and kindly ask another instruction on 29th November 2022 regarding publication of panel. The board published a notification where they stated on that day in the year 2022 that erroneous laws which is annexed, my lord.
We will ask Mr. Dotto what we say
panel
first, that to show us the order of. You will give us those orders.
Yes, because of that till date non-erroneous panel is not yet.
We will hear you.
Yes.
So please jump upon them, let them conclude.
Yes. Because with this procedure, another parallel procedure was there. Homen Nandi and Ramesh Malik, and that was in court knowledge.
We will sit at 2. We will continue till. এই ওটা রেকর্ড করে নাও তো 40 minutes এর বেশি দেবে না we will record it in our order that you will not take more than 40 minutes
Just like chess.
Mr. Dotto, learned senior advocate, appearing